Today we're going to talk about the ratification of the Constitution and the Bill of Rights. So we've already discussed the debate between the Federalists and the Anti-Federalists, and we know one thing that the Anti-Federalists were worried about is the fact that the Constitution never directly listed the rights of the people. And so essentially what we need to do is get to the compromise between the Federalists and the Anti-Federalists, which we know is that the Federalists accept the Bill of Rights, but in order to get there, let's talk about the rights that the Anti-Federalists were talking about that they wanted protected. And so today's goal is to explain the rights granted in the Bill of Rights. First of all, the Bill of Rights is the first 10 amendments to the Constitution. Originally, there were a few more that were proposed, but ultimately what the Founding Fathers agreed on were 10 amendments or 10 changes to the Constitution. And these 10 changes would represent the fundamental rights and freedoms of all people within the United States. We know the Declaration of Independence lists out the idea that people have natural rights or inherent rights, and the Bill of Rights has a list of what those exact rights are. The Bill of Rights is a compromise. Again, it is what we get to make the Anti-Federalists happy. The Anti-Federalists want the rights listed, and so that's what they're going to get in the Bill of Rights. So if we go amendment by amendment, the First Amendment to the Constitution can be remembered by the easy acronym RAPS: Religion, Assembly, Press, Petition, and Speech. First of all, the Constitution protects the freedom of religion. You have the right to the free exercise of religion, meaning you can practice whatever religion you want. In addition, you have the right against the government establishment of religion. If, for example, the government cannot force a religion upon you, and this is where we get the idea of separation of church and state. A stands for assembly. You have the right to peacefully assemble. Remember that during the Boston Tea Party and around that time, the Founding Fathers and really the people of Massachusetts were not permitted to publicly assemble in a public place. And so the right to publicly assemble was something that was important to our Founding Fathers. P for press. You have the freedom of press. In order to be able to criticize the government, people need to be able to freely publish or print what they see fit. The second P is for petition. You have the right to petition the government. What that means is if you're not happy with the government, you have the right to complain about the government. You have the right to write letters or call or protest outside the White House. You have the right to speak up for what you believe in, and if that means calling attention to the government, you have the right to express your opinions without fear of retribution by the government. Finally, we have S, speech. You have the freedom of speech. And this is the one that most people associate with the First Amendment. From the time you're a little kid, maybe you were like me and went to your parents, I have a freedom of speech, I have a freedom of speech. And indeed, the First Amendment protects your freedom of speech. So the easiest way to remember the First Amendment is RAPS: Religion, Assembly, Press, Petition, Speech. Now that being said, there are some limits to your rights in the First Amendment. You can't say or do or protest or whatever you want. There are limits, there are conditions to what you can do as listed in the Constitution. For example, you may have the right to freedom of assembly, but the government can also require you to have a permit to do so. Other limits is, particularly when it comes to freedom of speech or freedom of press, is that you cannot make false statements that harm a person's reputation. So you can print or publish or speak whatever you want as long as it's true, but if it is fake, if it is false, then you are not permitted to print that. And if you do, you could be sued. And so we have two different ways of describing this. First of all is libel. Whenever you write something that is false against somebody and it harms their reputation, we call that libel, which is the written part, and slander is the verbal version of libel. So there are some limits to what you can say. Of course, probably the most famous thing is you can't yell fire in a crowded building, or you can't yell bomb on an airplane. We already know that your freedom of speech is limited in those ways. The Second Amendment gives you the right to keep and bear arms. What that means is you have the right to carry a gun if you want. Now, there are some restrictions that are put on that as well. For example, in Washington, D.C., you are permitted to carry a gun. You are permitted to have bullets, but you're not allowed to have bullets and guns in the same place at the same time. but you still do have the right to keep and bear arms. The Third Amendment is kind of odd for us today because we don't really have this issue today, but back in the old days, citizens in the colonies were required to house British troops. So if troops were in the colonies, they would be forced to give up a bedroom and put them up, give them some food and clothing and drink, and that wasn't really the greatest thing for the colonists. Many of the colonists decided that they were paying a lot of money to house British soldiers in their spare bedrooms, and so the end result is the Constitution, and really the Bill of Rights, says that you do not have to allow the lodging of troops in your house. The Fourth Amendment protects you against search and seizure, so against illegal search and seizure. So pretty much if the government is going to search your property, they need a warrant. Now there are roughly 10 to 12, depending on the way you want to list it, situations in which you don't need a warrant to search somebody's stuff. Probably the most obvious one is the reasonable grounds. So if you can see that somebody is doing something wrong, or if you have what is called probable cause or reasonable grounds to search somebody's property, you can do so without a warrant. However, we'll get to those various conditions when we do the judicial branch. In addition, what the Fourth Amendment says is if the government does obtain something unlawfully, so if they don't have a warrant to search your stuff, then any evidence found cannot be used against you in a court of law. And this is what we call the exclusionary rule. The Fifth Amendment protects against a number of different things. Probably the most famous side is the I plead the Fifth. We'll talk about that in a second. But first of all, the Fifth Amendment sets out the principle of eminent domain. And what eminent domain means is that if the government wants to take your property, as long as they have a legitimate public use and they pay you fair market value, which is usually twice of whatever you're paying taxes on, then they have the right to take your property away. So for example, when they were building the I-96 freeway through Detroit, they paid a number of people in Detroit. Unfortunately, they were primarily African Americans who were kicked out of their houses, and they knocked down the houses and built the freeway. In addition, when they were building Comerica Park, there were a couple buildings that were in the middle of what is now center field, and those building owners didn't want to sell, and eventually the state just said, we invoke the right of eminent domain. We're going to take over your land, and as long as you get paid fair market value, you have the right to do so. Well, the government has the right to do so. The Fifth Amendment also protects you, probably more famously, in the criminal proceedings. So if you are accused of a crime, the Fifth Amendment says that if the government is going to charge you with a crime, you have to have a grand jury trial first. And what a grand jury means is essentially a group of people will just look to see if there's enough evidence to bring your case to trial. They're not trying to decide whether you're guilty or innocent. They're only trying to decide, does the state have enough evidence to proceed forward with the trial? And then the most famous part of pleading the Fifth, you have the right to due process in the event of a trial. So you do not have to testify against yourself in a criminal trial. However, if it's a civil trial, if somebody's suing you, you still have to testify against yourself. But if it is a criminal trial, if you are accused of a crime, you do not have to testify against yourself. And that's where the famous line in the TV shows come from. You are protected from self-incrimination. The Fifth Amendment also protects against what is known as double jeopardy. And double jeopardy means you are charged for the same incident of the same crime twice. That can't happen. Now, you can be charged for the same crime twice. If you rob a bank today and you rob a bank tomorrow, you can be tried today and tomorrow for robbing the bank. However, if you are found not guilty of robbing the bank today, then they can't come back and retry you hoping for a different verdict. Once you are found not guilty, that's it. It's done. Trial is over in a criminal case. The Sixth Amendment also protects you in the event of criminal proceedings, in the event that you're accused of a crime. It says that if you're accused of a crime, you are entitled to a speedy trial. So the police can't just put you in jail and hold you there for 20 years without a trial. You also have the right to a public trial so that people can see what's going on, and that public trial should be a jury of your peers. You are entitled to an impartial jury, so that jury cannot have any biases. There's a whole process that lawyers go through in order to determine whether or not a jury is biased. We can talk about that in class if you'd like. In addition, you have the right to confront witnesses. So if somebody accuses you of a crime, you have the right to put them on a stand and ask for more evidence as to why they are accusing you. And then, of course, most famously, you have the right to an attorney. And if you don't have one, one will be provided, but more on that later to come in a different unit. The Seventh Amendment protects you in the case of a civil trial. So if you're not accused of a crime, but if somebody is suing you, let's say I break the window out of your car and you want to get the money back, you can sue me. That is what is known as a civil case. Anytime we have a dispute between private citizens, that is a civil case. And the Seventh Amendment just says in any civil case that is valued at $20 or more, you have the right to a jury trial. Now, even though the Constitution hasn't technically been amended, generally speaking, today in federal court, you need $75,000. You need to be suing for $75,000 or more to have a jury trial. Although I guess technically if you wanted to push it hard enough, you might be able to argue that if it's over 20 bucks, you have the right to a trial by jury. The Eighth Amendment protects you against cruel and unusual punishment. It also protects you against excessive bail. Excessive bail means that if you are charged with a crime, until your trial is over, you have the right to go free, provided they don't think that you're going to leave the country or try to run away. All you have to do is pay what is known as bail or pay what is known as a bond. So you give the government, say, $1,000, and they let you go free, and as long as you come back, you get your $1,000 back. If you don't come back, they keep your money and they hunt you down and put you in jail for another crime. Cruel and unusual punishment, there were people who were tortured in pretty nasty ways. You can see in the picture they're doing what is known as tarring and feathering. What they would do is, in the old days, in the colonial days, is they would dip your body in a vat of hot tar, and then to add insult to injury, they dip you in a bunch of feathers just so you look ridiculous. Now, if this doesn't seem really too intimidating to you, think that the hot tar is probably several hundred, if not thousands of degrees, and when it gets put on your skin, it will burn your skin, and then when you try to peel the tar off, it peels the skin off along with it. So, needless to say, colonists were tired of that kind of practice, and they didn't want that to happen. Another type of cruel and unusual punishment, maybe my favorite or probably the most disturbing of all of them, drawing and quartering. The way this works is you take 4 horses, you tie a rope to each horse, you tie your arms and legs to the rope, and then you have the horse run in 4 different directions, which will break all your bones if they don't rip the extremities off. Very, very cruel and unusual punishment. The Eighth Amendment also protects you against habeas corpus. What that means is that if you are going to be brought to trial, there has to be some evidence to prove that you're worth holding. You can't be detained, you can't be held without any kind of proof or evidence. You can't just go and arrest people without a decent amount of proof and evidence, and that's the stuff that you would show to a grand jury, as we talked about earlier. Abraham Lincoln was famous because he arrested a number of Confederate war criminals without habeas corpus, without any evidence against them. He just said, well, we know that you're a spy for the Confederates, so we're going to hold you in prison until the war is over. That technically was a violation of their constitutional rights. The Ninth Amendment was put in there to make the Federalists happy. Remember, the Federalists were worried, what happens if we leave something out? What happens if we forget to list a right in the Constitution? And so the Ninth Amendment covers the unenumerated rights. What the Ninth Amendment says is that there are rights out there. We know that there are rights out there. And just because we don't list them in the Constitution doesn't mean they're not protected. So the Ninth Amendment says that there are unenumerated rights, rights that aren't listed in the Constitution, but they are still protected. For example, the Constitution doesn't say anything about your right to own a cell phone, yet we know you have the right to own a cell phone. It is one of those rights that is not listed in the Constitution, but is still protected even though it is not listed. And again, this was done to make the Federalists happy. Remember, the Federalists were worried if come up with too much of a list and we forget something, then it might imply that that's not protected. The Ninth Amendment says everything is. Going along with that, the 10th Amendment is put in place to make the Anti-Federalist happy. Remember, the Anti-Federalists were concerned that the national government might get too much power. So what the 10th Amendment says is that anything not listed, so all that stuff in the 9th Amendment, all those powers that are not directly listed in the Constitution, those are reserve powers. What that means is they're saved for the states. So if a power is not listed in the Constitution, it is up to the states to determine, protect, and run that power. So for example, the Constitution says nothing about getting a driver's license, but the 9th Amendment says that's still protected, and the 10th Amendment says it's the state's decision and the state's power to determine how driver's licenses are issued. So that's the first 10 amendments to the Constitution. That's the Bill of Rights. There are a few other key amendments. There's 27 total. You'll have to know a few more for your test, but we'll go over those in class probably tomorrow. With that said, I hope you have a wonderful day, and I hope you enjoyed this brief journey through the history of the Bill of Rights and some of your basic rights. Have a wonderful day.